ANC Secretary-General Ace Magashule is due in the High Court in Johannesburg, that's today and tomorrow in fact, challenging the party's decision to suspend him. Now, he was suspended after he refused to step aside pending his fraud and corruption trial. He, in turn, tried to suspend party president Cyril Ramaphosa. Magashule argues that the party's Rule 2570 is unconstitutional, adding that the ANC changed its step-aside rules in violation of its own constitution. The governing party, in turn, argues that it has the right to set its own internal rules, including dealing with errant members who face serious charges in court. Meanwhile, local courts have previously made rulings on internal political party matters. Let's unpack the story for you now. Constitutional expert Rebecca Sibanda joins us now for more. Rebecca, it's great to have you with us on what is a complicated but simple in some ways kind of a story. You know, case law tells us that the court has previously said that if a party's own constitution is in contradiction to the country's constitution, it will then step in. But the court also doesn't like to interfere with the internal workings of a political party.
Good morning, Michelle. Thank you for having me. You are very correct. So there's a delicate balance to be struck here. Where there is a blatant constitutional issue or a violation of any other laws in our country, the courts will definitely step in to protect the rights of those members who are concerned. However, like you said, where there is an internal issue, the courts are loath to interfere because one would assume those structures have gone, very far to make sure that the founding conditions as well as any other provisions to govern the conduct of members have been drafted with the Constitution in mind. So in this case, it's interesting to see that Magashule's argument is based on the Constitution and the presumption of innocence that we find in Section 35. It's interesting to me because as I think the ANC should be considered as any working organization, and in any working organization you have labor practices, labor laws, labor rules that follow or flow from the Constitution as well as all the labor laws that we have. Where any individual is found to have engaged in misconduct or gross misconduct, that person, enters the formal disciplinary processes of that institution. And we have seen that take place here. And the suspension is not an anomaly in any labor practices. Any financial or benefits that Magashule has not been taken away from him. He has merely been suspended pending the outcome of a court case. And this is standard practice in any formal institutional organization when an individual has been accused of misconduct. I'm unsure whether the courts are going to find in favor of Magashule in this case.
The other issue is that he argues in his court papers around the unconstitutionality of the step-aside rule, of that decision basically, in its entirety as it was taken at Nasrec in 2017. What will the court say about the fact that Magashule was there? He was at Nasrec in 2017. He was part of the consensus that was reached around the step-aside rule, and he now finds it unconstitutional and against the Bill of Rights apparently as well, since it affects him.
That, I think, is an interesting point that the court is going to have to deliberate on. Like you have said, he is one of the top-ranking members of the party, was before his suspension. He was present when the step-aside resolution was drafted and agreed upon in 2017. So to argue now that the resolution was created to specifically target him is a blatant lie. And I think the courts are going to see through that, see past that. And I think it's very dangerous for us or any political party to approach our courts to try and settle political scores. Our courts are not playgrounds for political party scoring. And I think that it is, especially if this court case is a malafide enterprise, it's a dangerous precedent to set if the courts spend a lot of time deliberating on the internal processes, the internal squabbles of political parties. Also, it's a waste of public funds. And I think it also would serve to distract us from very pertinent, pressing issues that the government is facing at the moment.
I mean, part of the problem that analysts are saying they have with Magashule's court papers and what we now know he plans to argue in court is that he's making claims that can be called sort of not factual, in effect, many of them quite false. For example, he claims that criminal charges he's facing is alleged failure to implement oversight in certain functions as a government official. That's not true. He faces actual charges of fraud, corruption, and money laundering.
He does. I think, if memory serves, more than 70 charges is what he's facing. And I think blatant lying or misrepresentation in court papers not only disrespects our democracy and our constitution, but it disrespects the integrity of our courts. To charge them with papers or a case that is very blatantly a political ploy, I think is disrespectful, for one, but also, like I said, a waste of our courts' time, and it is dangerous because it pulls our courts, our judiciary, into a political squabble. And that's not the purpose of our courts. Our courts are not here to serve at the pleasure of disgruntled politicians.
In terms of, a point that the Deputy Secretary General, Jesse Duarte, has made as well, in that several arguments that Magashule has made around reasons why the party cannot suspend him, cannot ask him to step aside, is that it, as I say, goes against the Bill of Rights, according to him, is unconstitutional as well. What's the issue in terms of labor law here? Do the basic tenets of labor law, insofar as any other employment is concerned, do they match up with your voluntarily joining a political party?
So the Constitution provides for a variety of your constitutional rights. And in this case, I think the ones that are concerned are the freedom of association. So Magashule joined the governing party years ago of his own prerogative, voluntarily rose up the ranks to a position of power. And he voluntarily associates with the ANC. The second right, I think I've already alluded to, is that the presumption of innocence in a criminal case, which he still has. He has not been found guilty of any of the charges with which he is facing. And the third are the fair labor practices that the Constitution provides for, and all the laws that flow from that provision. Like I said before, every individual who is in a formal institution or an organization is bound by procedures that institution organization puts into place. As a Secretary General, he is one of the individuals who is responsible for drafting and making sure that those procedures are enforced. And in this case, he just happens to be the person or the subject of labor practices or labor proceedings. He has faced the disciplinary committee, and they found unfavorably for him. And I think, like I said, this is perhaps the ploy of a disgruntled individual, as opposed to somebody who has been really violated or who has had their rights infringed in terms of the Constitution. And whilst many, political analysts or other constitutional law experts might think that this is a waste of time, we live in a democracy, and Magashule has every right to approach the court and show and prove that perhaps his rights have been infringed upon. This is what a democracy looks like. Even if we think that, or we are of the opinion that this is a waste of time or taxpayers' funds, he has every right to approach the courts and have his matter heard freely and in a fair trial, in an open manner. So if this is the path that he chooses, I would trust that the courts deal with the matter quickly, efficiently, so that we can move on to the criminal trial where he will face the charges. And I think it's important for us to remember that Magashule is not being charged as a member of the ANC. He is being charged for offences or misconduct that took place when he was a public servant in the Free State. Yep. And the Constitution is very clear on conduct of public servants as well. So I think we mustn't conflate the two court cases. One is a labor case and the other are criminal charges that he faces prison time for. So I hope that the courts will see this case for what it is and deal with it, expediently, so that we can move forward. And I think one more argument that he has made is that this step-aside resolution was drafted with him in mind. No, it was drafted for all corrupt officials, and it's unfortunate that it's taken the pandemic and it's taken, so much publicity for us to get to a point where the ANC is starting to take decisive action against corrupt officials. But this resolution was taken years ago, and he just happens to be the most prolific person or the most, popular person, highest ranking person to be, the subject of the step-aside resolution.
Absolutely. Rebecca Sibanda, I think we'll leave it there. Thanks very much for your time this morning. Some interesting analysis there, giving us some clarity on the case. Ace Magashule is taken to the High Court in Johannesburg. It'll be heard by a full bench today and tomorrow.